I knew something was wrong the moment I saw Patricia Whitmore's silver Lexus pulling up my dirt driveway. Dust clouds billowing behind her like she was leading a cavalry charge. I had just finished checking the fence line on the eastern pasture of my ranch in Sweetwater County, Wyoming. And the last thing I wanted was a visit from the HOA president, who seemed to think my 300-acre property was somehow part of her jurisdiction. My name is Cameron Lawson, and I had inherited this ranch from my grandfather 2 years ago. The old man had been a wildcatter back in the day, chasing oil prospects across Wyoming and Montana before settling down on this piece of land in 1978. He taught me everything about mineral rights, surface rights, and the complicated dance between them. That education was about to pay off in ways I never imagined. Patricia stepped out of her car wearing a cream-colored pantsuit that had no business being within 10 miles of a working ranch. She was in her early 50s with that particular hairstyle that screamed, "I want to speak to the manager," and oversized sunglasses perched on her head like a second set of eyes. Behind her, 2 other women emerged from the vehicle. Great. She brought reinforcements. "Mr. Lawson," Patricia called out, her voice carrying that fake sweetness that made my teeth hurt. "We need to have a conversation." I wiped the sweat from my forehead with my work glove and walked toward them, my boots crunching on the gravel. "Patricia, this is a surprise." I wasn't aware my property was part of the Sweetwater Springs HOA. Her smile tightened. "Well, that's actually what we're here to discuss. May we come inside?" Every instinct told me to say no, but curiosity got the better of me. I led them to the main house, a sturdy 2-story structure my grandfather had built with his own hands. The interior was exactly what you would expect from a working ranch functional, lived in, with more focus on comfort than decoration. Patricia and her companions, who introduced themselves as Susan Montgomery and Diane Fisher, settled themselves on my couch like they owned the place. I remained standing, leaning against the doorframe with my arms crossed. "So what's this about?" I asked. Patricia pulled out a manila folder from her expensive leather bag. "Mr. Lawson, are you aware that your property borders the Sweetwater Springs residential development? I'm aware there's a housing development about a 1/4 mile from my southern boundary. Has been there for 5 years. "Yes. Well," Patricia continued, her tone becoming more authoritative, "the HOA board has been reviewing our boundaries and entitlements, and we've discovered something quite interesting. It appears that the subsurface rights beneath a portion of your ranch actually fall under our purview." I felt my jaw tighten. "Excuse me?" Susan leaned forward, clutching a folder of her own. "We've had surveys done, Mr. Lawson. The mineral rights beneath approximately 100 acres of your property were never properly transferred when your grandfather purchased the surface rights. They remained with the original landholding company, which was later absorbed by the development group that established Sweetwater Springs. This was complete nonsense, and I knew it. My grandfather had been meticulous about documentation. He had fought tooth and nail to secure every mineral right on this property, knowing full well the potential value underneath Wyoming soil. "That's impossible," I said flatly. "My grandfather owned every mineral right on this land. I have the deeds." Patricia's smile widened. "Then you won't mind if we verify that, because we have documents suggesting otherwise. And I should inform you that the HOA has already entered into a preliminary leasing agreement with Patriot Energy Solutions for natural gas exploration on the disputed acreage." The room went silent. I stared at these 3 women sitting in my living room, telling me they had leased rights to land that wasn't theirs. My land. "You did what?" The words came out low and dangerous. Deanne spoke up for the first time, her voice nasally and irritating. The HOA board voted on it last month. It's all perfectly legal. The lease payments will go toward community improvements in Sweetwater Springs. Get out, I said. Patricia stood, smoothing her pantsuit. Mr. Lawson, there's no need to be hostile. We're simply following proper legal channels. If you believe you have rightful claim to these mineral rights, I suggest you contact an attorney. In the meantime, Patriot Energy will begin preliminary surveying next week. Get out. They left, but Patricia paused at the door. You should also know that the HOA bylaws now extend to properties within a 1-mile radius of the development. We'll be sending you information about compliance requirements. Your ranch currently has several violations we'll need to address. I slammed the door behind them hard enough to rattle the windows. The next morning, I drove into Rock Springs and walked into the office of Martin Hendricks, the attorney who had handled my grandfather's estate. Martin was in his 60s, with silver hair and wire-rimmed glasses, and he had known my family for 40 years. "Cameron," he greeted me, concern crossing his face when he saw my expression. "What's wrong?" I told him everything. As I spoke, his expression shifted from concern to confusion to outright anger. "They claimed what?" he asked, standing up from his desk. "They said Grandpa never owned the mineral rights to 100 acres, that it stayed with some landholding company." Martin shook his head vigorously. "That's categorically false. Your grandfather was obsessive about those rights. We have every deed, every transfer document, every quitclaim going back to the original land patent from the Bureau of Land Management. He owned the surface rights and the mineral rights, full stop. Can you prove it?" "Give me 2 days. I'll pull every document we have." He paused. "They said they already leased it to Patriot Energy Solutions. That's fraud. If they leased mineral rights they don't own, they've committed fraud. And if Patriot Energy didn't do proper due diligence, they're going to be in serious trouble too." I left his office feeling marginally better but still furious. On the drive back to the ranch, my phone rang. Unknown number. "Hello, Mr. Lawson. This is Richard Castellano from Patriot Energy Solutions. I'm the operations manager for the Sweetwater Springs project. I was hoping we could meet to discuss the survey schedule." My knuckles went white on the steering wheel. "You're trespassing on my land if you set foot on my property." "Sir, we have a valid lease agreement with the Sweetwater Springs HOA for subsurface access. We'll be conducting seismic surveys starting next Monday. We wanted to give you advance notice as a courtesy. Let me be crystal clear, Mr. Castellano. I own the surface rights and the mineral rights to every acre of my ranch. If you or your company enters my property, I will have you arrested for trespassing. If you attempt to drill or extract anything from beneath my land, I will sue you for theft and damages. Am I making myself clear?" There was a pause. "Sir, we have documentation." "I don't care what documentation you think you have. It's fraudulent. Stay off my land." I hung up and immediately called the Sweetwater County Sheriff's Office. I knew the sheriff, Tom Reynolds, from various community events. He was a no-nonsense guy who didn't appreciate people trying to pull fast ones in his county. "Tom, it's Cameron Lawson. I need to file a formal trespass warning." "What's going on, Cameron?" I explained the situation. Tom listened without interrupting, and when I finished, he let out a low whistle. "That's bold. You're sure about your mineral rights?" "My attorney is pulling all the documentation now, but yes, I'm certain. My grandfather made sure of it. I'll make a note of the trespass warning. If they show up, call us immediately. And Cameron, get those documents ready. If this is what it sounds like, this could get ugly." That was an understatement. Monday morning arrived with dark clouds rolling across the Wyoming sky. I was on horseback checking the herd when I saw them. 3 white trucks with the Patriot Energy logo drove past my gate and stopped at the fence line near my southern boundary. 4 men got out and started unloading equipment. I pulled out my phone and called the sheriff's office while simultaneously riding toward them. By the time I reached the fence, the men had set up what looked like surveying equipment just outside my property line. Richard Castellano was easy to spot. He was the oldest of the group, probably late 50s, wearing khaki pants and a company polo shirt. He saw me approaching and waved like we were old friends. "Mr. Lawson, glad you could join us. We're just setting up for the preliminary surveys." I stayed on horseback, looking down at him. "You're on notice, Mr. Castellano. If you or your equipment crosses that fence line, you'll be arrested for trespassing." He pulled out a folded document. "Sir, we have legal authorization to conduct surveys on this land. The mineral rights belong to me. And since I also own the surface rights, you need my permission to access them, which you don't have and won't get." One of the younger men, wearing a hard hat and safety vest, spoke up. "We can access mineral rights without surface owner permission if we have proper authorization from the mineral rights holder." I turned my attention to him. "That would be true if the HOA owned the mineral rights. They don't. I do. So unless you want to be charged with criminal trespass, theft, and whatever else my attorney can think of, I suggest you pack up and leave." A sheriff's deputy pulled up at that moment, lights flashing. Deputy Jake Morrison stepped out of his vehicle and approached the group. "Gentlemen, I'm going to need to see identification and your authorization documents," Jake said. The next 30 minutes involved a lot of paperwork, phone calls, and increasingly heated conversations. Richard Castellano called his company's legal department. I called Martin Hendricks. The deputy took statements from everyone. Finally, Jake turned to the Patriot Energy crew. "Here's the situation. Mr. Lawson has filed a formal trespass warning. Until the question of mineral rights ownership is settled in court, you cannot access this property. If you do, you'll be arrested." "Deputy, we have a valid lease," Richard protested. "That's a civil matter for the courts to decide. What I'm telling you is the criminal law. This is posted private property. The owner has denied you access. That's the end of the discussion." The Patriot Energy team packed up their equipment and left, but not before Richard handed me a business card. "You'll be hearing from our attorneys, Mr. Lawson. Looking forward to it." That afternoon, Martin Hendricks called me with news. "Cameron, I've compiled everything. Your grandfather's ownership is ironclad. Every document is in order, properly filed, properly recorded. There is absolutely no question that you own those mineral rights. So where did the HOA get their information? That's what's interesting. I did some digging. The HOA hired a company called Western Property Research to do title searches on properties around the development. Western Property Research is run by Patricia Whitmore's brother-in-law. The pieces started falling into place. So this is a scam. It appears to be. They create fake documentation suggesting unclear mineral rights ownership, then lease those rights to energy companies and pocket the money. By the time the fraud is discovered, they've collected substantial lease payments. How much are we talking about? Based on standard lease rates for this area, probably $200,000 up front, plus royalties if they actually extract anything. It's a lucrative con if they can pull it off. Can we file charges? We're going to do better than that. I'm filing an emergency motion for a declaratory judgment confirming your mineral rights ownership, plus a restraining order against both the HOA and Patriot Energy. And I'm sending a formal complaint to the county attorney about the fraud. How long will this take? The emergency motion. We should get a hearing within 2 weeks. The criminal investigation. That'll take longer, but once the county attorney sees the evidence, Patricia Whitmore is going to have a very bad day. 2 days later, I received a certified letter from the Sweetwater Springs HOA. Inside was a violation notice claiming my ranch was in breach of the HOA's expanded bylaws. According to the notice, I needed to paint my barn community-approved colors within 30 days, remove all agricultural equipment visible from the road, reduce the number of livestock on my property to comply with reasonable animal limits, pay a $5,000 inspection fee. The letter also informed me that I was being fined $500 per day for each violation, starting immediately. I called Martin immediately. He laughed when I read him the violations. "They're desperate," he said. "They know we've got them on the mineral rights fraud, so they're trying to harass you into dropping it. Don't worry about these violations. An HOA can't retroactively impose bylaws on property that was never part of the HOA to begin with. Can I countersue for harassment? Oh, we're going to do much more than that. This violation notice is going to look great in front of the judge. It shows a pattern of harassment and abuse of authority." The next week was tense. Patricia Whitmore escalated her campaign against me, sending daily violation notices. My mailbox was vandalized. Someone spread rumors in town that I was blocking vital economic development for the county. The local newspaper ran an article about conflicts between traditional ranching and modern development, clearly slanted in the HOA's favor. But I also had allies. Other ranchers in the area, who had dealt with HOA encroachment attempts before, reached out with support and information. Tom Reynolds, the sheriff, made it clear he wasn't buying Patricia's version of events. And most importantly, Martin Hendricks was building an airtight case. The emergency hearing was scheduled for October 15th in the Sweetwater County Courthouse in Green River. I arrived early wearing my best suit, which admittedly wasn't saying much. Martin met me on the courthouse steps with a leather briefcase that looked like it weighed 40 pounds. "Everything we need is in here," he said. "Original deeds, title documents, BLM records, geological surveys your grandfather commissioned, everything. Their attorney is going to try to create doubt about the chain of title. We're going to destroy that argument." Inside the courtroom, Patricia Whitmore sat with an attorney I didn't recognize. He was younger, probably early 30s, wearing an expensive suit and radiating the kind of confidence that came from winning a lot of cases. Behind them sat Susan Montgomery and Deanne Fisher, along with Richard Castellano from Patriot Energy, and another man in a suit who I assumed was their attorney. Judge Margaret Thornton entered, and we all rose. She was in her mid-60s, known for being sharp, fair, and not tolerating any nonsense in her courtroom. "Please be seated," Judge Thornton said. "This is an emergency hearing on the matter of Cameron Lawson versus Sweetwater Springs Homeowners Association and Patriot Energy Solutions, regarding declaratory judgment on mineral rights ownership and request for restraining order. Mr. Hendricks, you filed the motion. Please proceed." Martin stood and presented our case with the precision of a surgeon. He walked through my grandfather's original purchase of the land in 1978, showed the deeds transferring both surface and mineral rights, provided documentation of every subsequent filing and recording, and demonstrated an unbroken chain of ownership spanning 47 years. "Your Honor," Martin concluded, "there is absolutely no question that Cameron Lawson owns the mineral rights in question. The HOA's claim is not only wrong, it's fraudulent. They manufactured a title dispute where none exists, then leased rights they don't own to an energy company. This is textbook fraud. The HOA's attorney, who introduced himself as Bradley Simmons, stood to present their case. He immediately went on the offensive. "Your Honor, the ownership history isn't as clear as Mr. Hendricks suggests. In 1978, when Mr. Lawson's grandfather purchased the property, there was a split estate transaction involving multiple parcels. We have evidence suggesting that the mineral rights to the disputed acreage were carved out and retained by the original landholding company, Rocky Mountain Development Corporation." "May I see this evidence?" Judge Thornton asked. Bradley produced several documents. Martin immediately requested copies. As I watched Martin review them, his expression shifted from concern to barely suppressed anger. "Your Honor," Martin said, standing, "may I respond?" "Please do." "These documents are forgeries. First, the paper stock is wrong for 1978. Second, the notary stamp is for a notary who wasn't licensed until 1985. Third, and most damning, Rocky Mountain Development Corporation was dissolved in 1976, 2 years before Mr. Lawson's grandfather purchased the property. These documents claim to show a transaction by a company that didn't exist." The courtroom went silent. Judge Thornton held out her hand. "I'd like to see those documents, Mr. Simmons." Bradley's confidence evaporated as he handed them over. Judge Thornton examined them carefully, then looked at Patricia Whitmore with an expression that could freeze lava. "Mrs. Whitmore, where did these documents come from?" Patricia stood, her voice shaking slightly. "We hired a property research company, Your Honor, Western Property Research. They provided us with the title history. And you didn't verify this information before leasing mineral rights and entering into contracts worth hundreds of thousands of dollars. We trusted their expertise, Your Honor." "Whose expertise?" "Because I'm looking at documents that appear to be fraudulent." Judge Thornton turned to the bailiff. "Please contact the county attorney's office. Tell them I'm referring this matter for criminal investigation." Bradley Simmons tried to salvage the situation. "Your Honor, even if there are questions about these specific documents, the fundamental issue of mineral rights ownership should be thoroughly investigated before Mr. Simmons. Stop talking." Judge Thornton's voice cut through his protest. "I've reviewed Mr. Hendricks' documentation. The chain of title is clear, properly recorded and verifiable through county records. Your client's documentation is questionable at best and fraudulent at worst. The only thing I need to investigate is whether criminal charges are warranted." She looked at Richard Castellano. "Mr. Castellano, I assume you're with Patriot Energy." Richard stood. "Yes, Your Honor." "Did your company conduct due diligence before entering into this lease agreement?" "We reviewed the documentation provided by the HOA, Your Honor." "We also conducted our own title search, but it was preliminary." "So you leased mineral rights based on preliminary research and documentation provided by a party with a clear financial interest in the transaction?" "Your Honor, we believed." "I'm sure you did." "You should know that your company is now party to a fraudulent transaction. I strongly suggest you contact your own legal counsel." Judge Thornton spent another 10 minutes reviewing documents before rendering her decision. "This court finds that Cameron Lawson is the sole and rightful owner of all mineral rights on the property described in the filing. The Sweetwater Springs Homeowners Association has no claim to these rights. Any lease agreements entered into by the HOA regarding these mineral rights are void ab initio. Patriot Energy Solutions is hereby enjoined from conducting any surveying, drilling, or extraction activities on or beneath Mr. Lawson's property. Furthermore, I'm granting Mr. Lawson's request for a restraining order prohibiting the HOA from interfering with his property rights or entering his land without permission. She turned to Patricia Whitmore. Mrs. Whitmore, you and your HOA board are to cease all harassment of Mr. Lawson immediately. Those violation notices you've been sending, they're worthless. Your HOA has no authority over property that was never part of your association. If you continue this harassment, I'll hold you in contempt. Patricia looked like she had been slapped. Susan and Deanne stared at the floor. Judge Thornton wasn't finished. I'm also awarding Mr. Lawson attorney's fees and costs associated with this action. The final amount will be determined after Mr. Hendricks submits his fee statement. And as I mentioned, I'm referring this matter to the county attorney for potential criminal prosecution. This hearing is adjourned. As we left the courtroom, Martin was grinning. That went even better than I hoped. What happens now, the county attorney will investigate. Based on what Judge Thornton said, I expect criminal charges to be filed. Fraud, filing false documents, theft by deception, possibly conspiracy if multiple HOA board members were involved. Good. We walked out of the courthouse into bright October sunshine. Richard Castellano intercepted us on the steps. Mr. Lawson, I owe you an apology. Patriot Energy relied on false information. We should have done more thorough due diligence. Yeah, you should have, I said. For what it's worth, we're terminating our relationship with the HOA immediately and conducting a full internal review of our vetting procedures. This is embarrassing for the company. Expensive too, I imagine, Martin added. Richard grimaced. Very. If you'll excuse me, I have some very unpleasant phone calls to make. As he walked away, Martin turned to me. Want to grab lunch? We should discuss next steps. Over burgers at a diner in Green River, Martin laid out the situation. The criminal investigation will take a few months. The county attorney will need to interview witnesses, review documents, build the case. But based on what came out in court today, I'd be shocked if charges aren't filed. What charges are we talking about? In Wyoming. Probably theft by deception, which is a felony if the value exceeds $1,000. This lease was worth at least $200,000, so we're talking serious felony charges. Also filing false documents, fraud, possibly racketeering if they can prove this was part of a larger scheme. Could Patricia go to prison if convicted? Absolutely. White-collar fraud of this magnitude usually results in prison time, especially if there's no remorse or restitution. I thought about that while working on my burger. Part of me felt satisfied at the idea of Patricia Whitmore facing consequences. Another part of me just felt tired. I hadn't asked for any of this. I just wanted to run my ranch in peace. What about the HOA? I asked. Can they come after me for anything else? They could try, but after today's ruling, they'd be foolish to do so. Judge Thornton made it very clear that they have no authority over your property. If they continue harassing you, we can get contempt charges and additional restraining orders. Over the next few weeks, things quieted down. Patricia Whitmore stopped sending violation notices. The vandalism stopped. The newspaper ran a correction article about the court case, making it clear that the mineral rights dispute had been resolved in my favor. But I knew this wasn't over. The criminal investigation was ongoing, and rumors were swirling around Sweetwater County about what might come out. In late November, I got a call from Assistant County Attorney Michelle Harper. She wanted to interview me as part of the investigation. We met at her office in Green River, and I spent 3 hours walking through everything that had happened. Michelle was thorough and professional, taking detailed notes and asking pointed questions about every interaction with Patricia Whitmore and the HOA. Mr. Lawson, did Mrs. Whitmore ever acknowledge that she knew the mineral rights documentation was questionable? Michelle asked. Not directly, but she was very confident about it. She acted like it was a done deal. And the company that provided the research, Western Property Research. Did you know the owner is related to Mrs. Whitmore? My attorney discovered that. Is that relevant? Very. It suggests coordination and intent. If Patricia Whitmore's relative created fake documents that she then used to lease rights she knew she didn't own, that's conspiracy to commit fraud. How many people are you looking at? I can't discuss specifics, but I'll tell you this. The HOA board has 7 members. We're investigating all of them to determine who knew what and when. The next break in the case came from an unexpected source. In early December, Deanne Fisher showed up at my ranch. She looked terrible, like she hadn't slept in days, her eyes red from crying. "Mr. Lawson, I need to talk to you," she said when I answered the door. "If this is about the case, you should talk to your attorney. Please." "I just need 5 minutes." Against my better judgment, I let her in. We sat at my kitchen table and Deanne broke down. "I didn't know," she said, tears streaming down her face. "I swear I didn't know Patricia was using fake documents. She told us the mineral rights research was legitimate. She said we could make money for the community while also putting pressure on you to sell your ranch." "Why would the HOA want me to sell my ranch?" "Patricia had a developer interested in buying your land. Some company from California that wanted to build a resort. She said if we could make things difficult enough, you'd sell, and the HOA would get a finder's fee." The pieces fell into place. This wasn't just about mineral rights fraud. It was about forcing me off my land entirely. "Did you tell this to the county attorney?" Diane nodded. "I'm cooperating with the investigation. My attorney worked out an immunity deal. I'm testifying against Patricia and the others who were involved." How many others? Susan Montgomery knew. So did the HOA treasurer, Mark Brennan, and the vice president, Jennifer Collins. They all knew about the plan. The other 3 board members were kept in the dark. "Why are you telling me this?" "Because I'm sorry. I know that doesn't fix anything, but I want you to know that not everyone was in on this. Some of us thought we were doing legitimate HOA business. By the time I realized what was really happening, it was too late. After Deanne left, I called Martin and told him about the conversation. He was intrigued but cautious. Cooperating witnesses are good for the prosecution. It means they have someone on the inside who can explain how the scheme worked. But don't let your guard down. Deanne might be trying to minimize her own culpability. She seemed genuinely sorry. She might be. Or she might be sorry she got caught. Either way, let the county attorney handle it. The holidays passed quietly. I spent Christmas with my aunt in Casper and returned to the ranch for New Year's. As 2025 began, I focused on ranch work and tried to put the whole mess behind me. But the legal system moves on its own schedule, and in mid-January, everything came to a head. On January 20th, the Sweetwater County Attorney's Office announced criminal charges against Patricia Whitmore, Susan Montgomery, Mark Brennan, and Jennifer Collins. The charges included theft by deception, conspiracy to commit fraud, filing false instruments, and attempted grand theft. Patricia faced additional charges for her role as the ringleader. The news hit Sweetwater Springs like a bomb. The HOA immediately dissolved its current board and installed new leadership. The development's residents were in shock, many of them having trusted Patricia to manage their community. Martin called me the day the charges were announced. "This is good news, Cameron. It validates everything we've been saying, and it's going to make your civil case much stronger." "Civil case? You didn't think we were done, did you? You've suffered financial damages from this fraud. Legal fees, time spent dealing with this mess, emotional distress. We're going to sue the HOA and the individuals involved for everything we can get." "How much are we talking about?" Based on your attorney's fees alone, we're looking at $50,000 minimum. But we could argue for much more based on the harassment, defamation, and attempted theft of your mineral rights. I'd estimate we could seek damages in the $500,000 to $1 million range. That was life-changing money. More than enough to expand my operation, hire help, maybe finally fix the irrigation system that had been giving me trouble for 2 years. Do it, I said. Martin filed the civil suit in February. The defendants, facing criminal charges and now a massive civil lawsuit, began turning on each other. Mark Brennan's attorney reached out about a settlement. Jennifer Collins filed for bankruptcy. Susan Montgomery tried to claim she was just following Patricia's orders and shouldn't be held responsible. Patricia Whitmore fought everything. Her attorney filed motion after motion, trying to dismiss the charges, suppress evidence, delay the trial. Nothing worked. The evidence was overwhelming, and Judge Thornton had already established the fundamental facts in her declaratory judgment. The criminal trial was set for May. As spring arrived in Wyoming and the snow melted from the high country, I found myself preparing to testify against the woman who had tried to steal my family's land. The trial lasted 2 weeks. The prosecution called witness after witness, building a methodical case that showed exactly how the fraud had been perpetrated. Diane Fisher testified about the HOA board meetings where the scheme was discussed. A forensic document examiner testified that the mineral rights documents were recent forgeries. County records officials testified about the proper documentation in my grandfather's file. I testified on day 4. The prosecutor, Michelle Harper, walked me through the timeline of events. Patricia's attorney, a different lawyer now after Bradley Simmons had withdrawn from the case, tried to make me seem like an uncooperative neighbor who was blocking legitimate development. Mr. Lawson, isn't it true that your ranch creates noise, odors, and traffic that negatively impact the Sweetwater Springs development? He asked during cross-examination. My ranch was here first, I replied. People who bought houses next to a working ranch shouldn't be surprised that ranching happens. But you've been resistant to any compromise with the community, haven't you? I've been resistant to fraud and theft. If that's what you mean by lack of compromise, then yes. The prosecutor's rebuttal was devastating. She presented evidence that Patricia had been in contact with the California Development Company since before the mineral rights scheme began. Emails showed her discussing how to persuade the stubborn rancher to sell, and mentioning that creating legal complications might motivate a sale. The jury deliberated for less than 6 hours. When they returned, the verdict was guilty on all counts for Patricia Whitmore. Susan Montgomery was convicted on most charges. Mark Brennan and Jennifer Collins were convicted on lesser charges, but still faced serious consequences. Sentencing came 2 weeks later. Judge Thornton addressed each defendant individually before imposing sentences. Mrs. Whitmore, she began, you were in a position of trust within your community. People elected you to manage their HOA to protect their interests. Instead, you abused that trust to perpetrate a fraud that could have resulted in the theft of land rights worth millions of dollars. You forged documents, you lied to your fellow board members, and you coordinated with your relatives to create false evidence. This was not a mistake or an error in judgment. This was a deliberate, calculated scheme motivated by greed. Patricia stood stone-faced, her hands clasped in front of her. I'm sentencing you to 5 years in the Wyoming Women's Center, followed by 3 years of supervised probation. You are also ordered to pay restitution in amounts to be determined after the civil case concludes. Do you have anything to say? Patricia's voice was quiet but defiant. I was trying to help my community. That ranch doesn't belong next to our development. I made mistakes, but my intentions were good." Judge Thornton's expression hardened. "Your intentions were to profit from theft. Take her into custody." The bailiff led Patricia away. Susan Montgomery received 3 years in prison. Mark Brennan and Jennifer Collins each received 2 years plus probation. As I left the courthouse that day, I felt a weight lift from my shoulders. It was over. The people who had tried to steal my land were going to prison. Justice had been served. But Martin reminded me that the civil case was still pending. "Now we negotiate from a position of strength. They've been criminally convicted. No jury is going to be sympathetic to them." He was right. Over the summer, we reached settlements with all the defendants. Mark Brennan's insurance policy paid out $75,000. Jennifer Collins agreed to pay $25,000 over 10 years. Susan Montgomery settled for $50,000. Patricia Whitmore's assets were seized, including her house, which was sold to pay restitution. In total, I recovered over $300,000, which more than covered my attorney's fees and compensated me for the nightmare year I had endured. The Sweetwater Springs HOA, under new leadership, formally apologized and paid an additional $100,000 to settle the organization's liability. They also amended their bylaws to make clear that the HOA had no jurisdiction over properties that weren't part of the original development. By the time fall arrived and I was once again checking fence lines and preparing the herd for winter, my life had returned to something resembling normal. The ranch was doing well. I had money in the bank for improvements and emergencies. The harassment had stopped. One afternoon in October, I was in town picking up supplies when I ran into Deanne Fisher at the hardware store. She looked healthier than the last time I had seen her, less burdened. "Cameron," she said. "How are you? Doing well? You? Better. I'm moving to Colorado next month. Fresh start." I wanted to thank you. Thank me. For not fighting my immunity deal. You could have made things harder for me. I know I don't deserve your forgiveness, but I appreciate that you didn't try to punish me more than I already was. I thought about that. Deanne had been stupid and complicit, but she had also come forward and testified. She had helped bring Patricia to justice. "We all make mistakes," I said. "What matters is what we do after." She nodded, tears in her eyes. "I hope your ranch thrives. You deserve it." As I drove home that evening, watching the sun set over my land, I thought about everything that had happened. Patricia Whitmore had tried to steal my family's legacy, the mineral rights my grandfather had fought so hard to secure. She had thought she could bully a rancher, forge documents, and get away with fraud. She had been wrong. The ranch was still mine. The surface rights, the mineral rights, every blade of grass and every drop of oil that might be underneath. My grandfather would have been proud. He had always told me that in Wyoming, your word and your deed meant everything. He had kept his word and maintained his deeds. Now I had done the same. I thought about whether to lease the mineral rights myself someday. Natural gas prices were climbing, and Patriot Energy had been right about one thing. There was probably significant value under my land. But that was a decision for another day. For now, I was content to run my cattle, fix my fences, and live the life my grandfather had built. As I pulled up to the ranch house, I noticed something unusual. A car was parked near the barn, but it wasn't anyone I recognized. I approached cautiously, then saw a man in his 30s get out, holding a briefcase. "Mr. Lawson, I'm Derek Foster from Mountain West Energy. I was hoping I could talk to you about your mineral rights." I had to laugh. "You're persistent, I'll give you that. I've read about your case. That was quite a legal battle. I want to assure you that our company does thorough due diligence. We would never rely on questionable documentation." "Why should I lease to you?" Because the geology under your land is exceptional. My company specializes in ethical extraction with minimal surface impact. We can offer you a fair lease with terms that protect your ranching operation. You could make significant money while still running your cattle. I looked at him for a long moment. How much money? Based on preliminary surveys of the surrounding area, we estimate you're sitting on natural gas reserves worth $20 to $30 million. A standard lease would give you a $500,000 signing bonus plus 12.5% royalties on everything we extract. That was real money, life-changing money, generational wealth that could secure my family's future the way my grandfather had tried to secure mine. "Give me your card," I said. "I'll have my attorney review any proposal you want to make. If it protects my surface rights and the ranch operations, we can talk." Derek smiled and handed me his card. "That's all I ask. Take your time. The gas isn't going anywhere." After he left, I stood in my driveway looking at the business card. My grandfather had held onto these mineral rights for nearly 50 years, never leasing them, never selling them. He had known their value and preserved them for future generations. Now I had the chance to realize that value while still maintaining the ranch, but I would do it right. No shady HOA deals, no forged documents, everything legal, everything transparent, everything protecting what mattered most, the land itself. I walked into the house and called Martin Hendricks. "Martin, I might need your help vetting an energy company. Another mineral rights situation. This one's legitimate, or at least I want to make sure it is before I even consider it. Send me the information. We'll do complete due diligence. After what you've been through, we're not taking any chances." That night, I sat on my porch with a beer, watching stars emerge over the Wyoming landscape. The ranch was quiet except for the occasional sound of cattle and the wind moving through the grass. This land had been in my family for 47 years. My grandfather had built something here, something worth fighting for. Patricia Whitmore had tried to take it through fraud and intimidation. She had failed because she underestimated how much this land meant, and because she thought she could get away with criminal behavior. She had been wrong on both counts. The legal battle had been exhausting and expensive and infuriating. But it had also taught me something important. The law, when properly applied, protects the righteous. Documents matter. Truth matters. And sometimes the little guy, the rancher standing alone against an HOA and an energy company, can win. Over the next few months, Martin vetted Mountain West Energy thoroughly. He reviewed their corporate structure, their history, their previous leases, their environmental record. He consulted with other attorneys who had dealt with them. He negotiated every term of the proposed lease agreement to ensure my surface rights were protected, and the ranch could continue operating without interference. In February, 1 year after the civil suit was filed and nearly 2 years after Patricia Whitmore first drove up my driveway, I signed a mineral rights lease with Mountain West Energy. The signing bonus of $500,000 hit my bank account 3 days later. The lease terms specified that all drilling had to be done from off-site locations using directional drilling, which meant no rigs on my property, no disruption to my cattle, no interference with ranch operations. It was everything my grandfather had hoped for, the value of the mineral rights realized while preserving the ranch itself. I used some of the money to upgrade equipment and hire 2 full-time ranch hands, which made the daily work much more manageable. I fixed the irrigation system, repaired the barn, and bought a new truck to replace the one that had been on its last legs. I put a significant amount into savings and investments, ensuring that even if the mineral extraction ended tomorrow, I would be financially secure. But the best use of the money, in my opinion, was the scholarship fund I established at the University of Wyoming for students studying agriculture and land management. I named it after my grandfather, the man who had understood that land rights, both surface and mineral, were the foundation of wealth and security in Wyoming. The first recipient was a young woman from Laramie who wanted to be a ranch manager. At the award ceremony, I told her my story about the HOA that tried to steal my mineral rights and the legal battle that followed. The lesson, I said, is to know what you own and to protect it. Documentation matters. The law matters. And never let anyone bully you off your land, no matter how official they seem or how many lawyers they have. She thanked me, and I could see the determination in her eyes. She was going to be a good rancher. As spring 2026 arrived and I watched my herd grow and my ranch thrive, I reflected on everything that had happened. Patricia Whitmore was in prison, serving her sentence at the Wyoming Women's Center. The other conspirators were also behind bars or on probation, their lives permanently marked by their criminal convictions. The Sweetwater Springs HOA had been reformed and was now run by people who understood the limits of their authority. And I was still here, on my land, running my ranch, with my mineral rights intact and producing income that secured my future. My grandfather used to say that Wyoming was a place where a man could make his stand. He had been right. This was land worth fighting for, rights worth defending, a legacy worth preserving. I had made my stand against an HOA that thought it could steal what wasn't theirs. I had fought them in court, exposed their fraud, and watched them go to prison for their crimes. And in the end, I had not only protected what was mine but had turned it into something even more valuable. The ranch stretched out before me in the morning light, 300 acres of Wyoming rangeland that belonged to me, surface and subsurface, from the grass to the minerals far below. My grandfather's legacy, my present, my children's future if I ever had them. Patricia Whitmore had tried to lease the ground beneath my ranch, not knowing I held every mineral right on it. That ignorance, combined with her criminal arrogance, had cost her everything. Meanwhile, I was still here, still ranching, still fighting for what my family had built. And I wasn't going anywhere. The lesson was simple but profound. Know what you own, protect it fiercely, and never underestimate a rancher who has the law on his side. My grandfather had taught me that. Patricia Whitmore had learned it the hard way. As I finished my morning coffee and prepared to start another day of ranch work, I thought about the future. Mountain West Energy would begin extraction later this year, and the royalty checks would start flowing. The ranch was profitable and growing. The legal battles were over. The criminals were in prison. Life was good. I climbed into my truck and headed out to check on the herd, driving past the fence line where Patricia Whitmore and Patriot Energy had once stood, trying to claim rights they didn't own. That spot was quiet now, just another section of fence on a working ranch. But I remembered. I would always remember the day I learned that sometimes the little guy wins, especially when he has right on his side and the patience to see justice through to the end. The HOA had leased the ground beneath my ranch, not knowing I held every mineral right on it. That mistake had destroyed them and vindicated me. It was a story I would tell for years to come, a reminder that in America, property rights still mean something and the law still protects those who stand their ground. My grandfather would have been proud. Hell, I was proud. This was his legacy and I had defended it. Now it was time to build on it, to make this ranch even better, to ensure that future generations of Lawsons would work this land and benefit from the mineral wealth beneath it. As I reached the eastern pasture and saw my cattle grazing peacefully under the Wyoming sky, I smiled. This was where I belonged. This was home. And no HOA, no matter how bold or how criminal, was ever going to take it from me. The ground beneath my boots was mine. The grass, the soil, the minerals far below, all of it belonged to Cameron Lawson, just as it had belonged to my grandfather before me. We had the deeds to prove it, the legal victories to confirm it, and the determination to defend it against anyone who thought they could take it. Patricia Whitmore was in prison, learning that lesson the hard way. I was on my ranch, living the life my grandfather had fought to give me. Justice had prevailed. The land remained in the right hands, and that was worth more than all the mineral rights in Wyoming.